If the buyer who's buying your home decides to cancel the contract, what happens to the deposit money? It's a good question. Today is day 22 of Mark Madness. Hey everyone, and welcome to day 22 of Mark Madness. I'm your host, Mark J. Schmidt of Remax Country and MoveMeMark.com. Mark Madness happens every day in March, and it's where I give you great tips, advice, ideas, suggestions, everything you can use to make sure your next move is a huge success. Be sure to tune in every day on my Facebook page at facebook.com/MoveMeMark so you don't miss out. But thanks so much for tuning in today. I really do appreciate it. So today the question is, you have your home for sale, you find a buyer, you go under contract, and then the buyer decides to walk away. What happens to the deposit money? Now, many years ago, now I've been selling real estate for 16 years, and this happened before then. Many years ago, if the buyer walked away from a contract, the seller could keep the deposit money. And there are differing laws and differing ways of doing things depending on the state that you're in. Here in New Jersey, if a buyer decides to walk away from a contract, really the deposit money does not automatically go to the seller. Now, according to the terms of the standard contract of sale that we use here in New Jersey, really the best option for the seller is to sue the buyer for any damages that they have. The deposit money is not automatically given to the seller. Now, there are, for a little refresher course, if you don't recall, there are three ways that a deal can really fall apart when you go under contract. The first is during attorney review. That's when either party has the right to cancel the contract for any reason. You can sign that contract, go into attorney review. If the buyer sees something else, they can kill the deal. And if you as the seller, if you decide that you have another offer come in that you'd rather accept, you can kill the deal for that second offer. So attorney review is the first one. Second one is home inspection. A lot of deals can fall apart because of home inspection issues. Maybe the buyer sees things that they don't like. Maybe you just can't come to terms on repairs, and the deal can fall apart that way. The third way is called the mortgage contingency clause. We did a video about that a little while ago, and that's basically the mortgage contingency clause is the date by which the buyer has to have their mortgage commitment. If they don't have the commitment by that date, then either party can cancel the contract. So unless there's been a breach of the contract, if the if the buyer has done something that is just outside the scope of the contract and they've actually breached the contract, then you can take legal action against them, but you're not going to automatically get the deposit money. It just doesn't happen. So listen, if you have any questions about buying or selling a home, please give me a call anytime. You can reach me at 908-705-5110. And don't forget to check out my blog on my website. That's www.MoveMeMark.com. Lots of great stuff there. Anyway, thanks so much for tuning in to today's episode of Mark Madness. I'll see you tomorrow. Have a great day.